In a years-long legal battle after a Colorado Springs business sued one woman for leaving them a negative online review.
News 5's Maggie Bryan has more on the court's recent decision and what it means for free speech in Colorado.
The Colorado Court of Appeals has ruled in favor of the woman who left the review and has dismissed the company's claims of defamation. It's all because of a law we have here in Colorado called Anti-SLAAP, enacted in 2019. SLAAP stands for Strategic Lawsuits Against Public Participation. It's made to bar people or businesses from silencing critics through free speech lawsuits. The attorney for Smith Plumbing and Heating says, however, the court's recent decision is not how anti-SLAAP law was intended to be practiced. Thousands of online reviews are left for businesses each day from consumers about products and services. But it was this one that put Liz Watson in a courtroom facing a defamation lawsuit.
It was my opinion and it was what I felt.
We reported on this story back in 2021 when Watson contacted Smith Plumbing and Heating for a free estimate for several home repairs. In these court documents, she says technicians came to her house and gave her an estimate of more than $20,000 for the services. Watson says she got second opinions from other providers and claims in legal documents the estimates came back at a fraction of the cost. Watson then left a negative review on Smith Plumbing and Heating's Facebook page, saying they tried to charge her $23,000 for $10,000 in work, while comparing the quotes from other businesses to theirs in her post. She continues to say the business really tried to take advantage of this single parent. So you're saying without that last line in that post, there would be no lawsuit in the first place?
Yeah, that was the tipping point.
2 days later, the general counsel for the company sent Watson this letter demanding $10,000 in damages and to take down the post or they would file a defamation lawsuit.
It's outrageous for you to say it takes advantage of a single mother or anything like that when none of that is true, factual, or has any evidence to back it up.
Watson refused to delete the post, and an attorney representing Smith filed a lawsuit and requested a jury trial. In these court documents, the company claims Watson left out key facts from her online review, that estimates from other businesses were not comparable to theirs because they involved different work, equipment, and warranties. Cassandra Kirsch, the company's attorney, says the estimate from Smith Plumbing and Heating was higher because technicians found code violations that needed repairs.
That didn't match up with the invoices. The numbers didn't match up because when you get rid of the code violations, the cost she's quoting is essentially the same. So there really was no predatory pricing.
The business's attorney says Watson posted the review with malice or the intent to harm the company. Ian Spear, Watson's attorney, says that is not true.
Liz's review was protected speech under the First Amendment.
He filed a motion to dismiss the suit with the trial court, citing Colorado's anti-SLAAP law, which was made to protect individuals from retaliatory lawsuits against those speaking out on public issues. Would you say that anti-SLAAP laws are made to protect someone like Liz?
Yeah, absolutely. That's what they're there for. They're designed to protect against abusive lawsuits. She's a single mom and a Costco employee. She doesn't have the resources and didn't have the resources to defend a lawsuit.
In 2022, the trial court denied the request to dismiss the company's claims, saying it agreed Watson's Facebook post met the basic definition of defamatory under Colorado law. Watson's attorney appealed the ruling, and just 2 weeks ago, the Court of Appeals ruled in favor of Watson and her online review.
The Court of Appeals said this is a pretty factual and substantially true review. Ends with a statement of opinion, it's protected.
In its ruling, the court says Watson's post was about a matter of public concern, that her review was a statement of opinion, and that the business would not be able to win at trial. The business's attorney says this is not how the anti-SLAAP statute was intended to be used.
A statute that was intended to be a shield is being used as a sword to keep legitimate plaintiffs out of court.
Mike Robinson, the general manager of the plumbing company, says the statute should be used to protect individuals from large corporations, not small businesses like his.
We're a mom and pop company. Every dollar that we put in towards this case is a dollar that doesn't go to bonuses or new uniforms or enhanced benefits for our people.
When asked how much the company has spent on the lawsuit, the attorney for Smith Plumbing told News 5 she could not disclose the amount. The general manager claims this ruling could lead to a free-for-all for consumers and competitors to smear businesses through online reviews.
This is more about, can you publish things that are untrue, that you know are untrue, that are fabricated.
The company says in court documents that it shut down its social media for a week and said employees faced real-world harassment.
It was just out of control, obnoxious. People who had no idea the facts of the case, had heard a snippet.
In my view, the Court of Appeals got it right.
Attorney Steve Zansberg was a key stakeholder in getting Colorado's anti-SLAAP law passed. He says the court used the law exactly how it was intended.
It appropriately applies our anti-SLAAP statute for the benefit not just of a defendant, here a consumer who voiced her concerns about business practices, but for the benefit of all of us to receive that information.
He says because the court denied a request by Watson to publish the decision, the ruling will not become a precedent.
It can be cited to trial courts for persuasive authority, but it is non-binding. It is not a precedent.
The company's attorney says they are asking for a rehearing from the Court of Appeals and for the Colorado Supreme Court to take on the case.
At the end of the day, consumers and businesses alike need to have this confusion cleared up.
We need to make this right for other people that come behind us and really give businesses still a chance to be able to counter or challenge these malicious, untrue, and libelous reviews.
Zansberg says it is unlikely the Colorado Supreme Court will hear the case since the Court of Appeals unanimously dismissed it.
I'm surprised that they're still trying to pursue it. It's stressful, thinking that I have to deal with it maybe again down the road.
In the meantime, Watson is standing by what the Colorado Court of Appeals has now ruled as protected speech.
Being able to just express your experience and express your opinion about a provider, that's protected speech. You know, that's something that everybody should have the right to be able to choose and read those and decide what they're going to do with their own money and how they want to spend it.
The attorney for Smith Plumbing and Heating says today they have filed a petition for a rehearing.